Hi, everyone. Harry here to talk about what happens now with USA versus Trump, the January 6th prosecution back in Judge Chutkan's courtroom. We've waited a while. The court took the case about at the beginning of the year, went all the way through the very end of the term, issued it July 1st, and then an extra 32 days just because that's the normal time in order for a case just to be prepared and wrapped in a ribbon in order to be shipped back to the court from whence it came. Now, that's at least the old timelines. Now what happens is on the day you push a button, the email goes to the court from whence it came. That was, recall, the D.C. Circuit, the court between Judge Chutkan and the Supreme Court. They pushed a button, boom, D.C. Circuit. D.C. Circuit pushed a button, boom, now back in Judge Chutkan's courtroom. What is she gonna do with it? All right, she issued an order, and this was to be expected. You would normally tell the parties to come together and give their respective versions of what should happen. And basically, in this ultra-contentious case that's now governed by a cryptic, very complicated Supreme Court immunity decision, every step, every gesture, every hiccup will have two sides arguing about what should happen. Now, what she technically has done is said, we'll have a status hearing in a couple weeks, the 16th. That's a little bit long, just a little. You would normally think maybe a week to 10 days. I believe, though, there was an indication way back when that Judge Chutkan was going to be away in August. So I think that's what's going on. 2 weeks. What happens during these 2 weeks? The parties file a so-called joint conference statement. So it's one piece of paper, and Trump's lawyers and Jack Smith and his lawyers are both on it. And they lay out the issues before the court and their views about what should happen. So the platonic version of this would be that, okay, next you have to figure out what's immune and what's not. And here's the parties agree that means taking it in this order and deciding these issues. That will not happen here. Especially Trump's folks have shown themselves to be obstreperous and obstructionist at every turn. So instead, it's going to be a very frustrating for Judge Chutkan document. Nothing but frustrations lie ahead for her because the Supreme Court's guidance is so cryptic, and she now has sort of on her back and the court, and on that back, the Court of Appeals and the Supreme Court ready to knock her if she does anything at all, not even off base, but that they decide is off base. Okay, so the document that she's going to receive will instead look like something, they'll agree on the caption. They'll agree on the date of the hearing, really, almost every single little issue, the order of deciding things, the basic law to apply, everything. And this is not a long brief. This is just sort of setting out what we do now. We'll have Jack Smith's version, Trump's version, Jack Smith's version, Trump's version, the design of a consolidated document where you take the things you agree on and make those easy for the district court. That's just not how it's going to work here. You're going to have everything contentious, okay? So for January 6th, she will have that document. And now the question before her will be how to proceed. And this serves up this very important issue that's been kind of hovering around ever since it's been clear that Judge Chutkan was not going to see this case in any time like required to actually hold a trial. But there's been a lot of commentators holding out hope, and you can look in all the papers this morning. This idea has gotten into the water that Chutkan can hold an evidentiary hearing. because her basic task now is to take this big, and Smiths and all the parties take this big indictment, 4-count, 45-page indictment with sort of 5 separate stories interwoven in it, and decide what's immune under the Supreme Court's guidance. And then, so, you just scalpel away the immune part and keep the rest and go forward. Or Jack Smith scalpels away the immune part and presents a new indictment that doesn't have the immune part, right? So here's a great idea. To sculpt away the immune part, let's use some evidence, because the court suggested in a particularly cryptic part of its opinion, it's going to be a contextual, even use the word fact-bound decision. So let's get those facts up there and we can decide. Jack Smith calls Mike Pence to the stand because the Supreme Court said that the conversations between Pence and Trump, a lot of them would be immune, but let's say Pence is acting in his role as head legislative guy in the Senate, and that's not an official part of the president's duties to interact with him when he's got that hat on. Good. Let's call him up, put him on the stand. Raise your right hand, Mr. Pence. Okay, what did Donald Trump say to you, like off the dining room we know what we said to him, which is, you're ruining your career. You're a total failure. He totally lambasted him. So, all right, now we know we can use that evidence, but not so fast. So I am to put my cards on the table. Of the if they are bullish, I guess that makes me bearish, right? I don't see this happening. Why not? First, Trump won't want it to happen. It's the exact flip side. He wants. Jack Smith wants, and some of the anti-Trumpers want, the headlines of Pence says that Trump told him that these things would happen, and totally castigated him, etc. But we have a chicken and egg game here, because the Supreme Court, you may well know by now, didn't just say you're immune for certain conduct, but evidence that itself is immune, and there can be quite a lot of that, can't come in the first place, because that would be the same, said the Supreme Court, and if you think about it, a non sequitur, a nonsense kind of proposition that is now the law of the land, that could undo the whole thing. So here's what I see playing, Your Honor. Let's have an evidentiary hearing. We'll call your first witness. Objection, Your Honor. What they want to put him on and get him to give official testimony. The things he's going to say are part of exactly what the Supreme Court said couldn't happen. Well, no, Your Honor, look, we'll be careful, and we think we can tack around it, and let's just do it. And if Your Honor sees that, she could. No, Judge Chutkan, you're not allowed to hear this, and fact finder, it can't go out to the American people. Now what? And basically, I can surmise how this would be handled under the Supreme Court's opinion, but the bigger point is I see them being able to freeze proceedings here and say, we can't put this, on unless it's immune, but we can only put it on. How can we figure out if it is immune? Here's a suggestion that the Trump camp might give. You can't. What you can do is just look at the allegations in the complaint. Those aren't evidence, just allegations, and talk about those. Are those allegations kosher? And if they are, we can maybe go forward with a very, very careful question by question oversight of, are you getting into forbidden territory of offering up immune testimony? But to me, that whole game, that whole chicken and egg maneuvering is more than enough time to stall an evidentiary hearing until after the election. And that's because this is immunity. And the whole reason the Supreme Court was able to reach down and take this case away from Judge Chutkan is immunity encompasses a right not to be tried in the first place. And I think the Supreme Court would say not to have certain evidence aired in the first place. And therefore, if the district court rules against you, you get an appeal right away. You don't wait till the whole trial's over and see if a mistake was made, as you do with almost every kind of legal objection. So to me, and I think Chutkan will be cautious, will not want to be slapped down again. She acted impeccably as a judge. The Court of Appeals, in its bipartisan opinion, acted impeccably, persuasively, and the Supreme Court just came along and mowed them down, and they could do the same thing here. So to me, I think what is afoot is going to be this kind of battle that Trump will say, we can't have this evidentiary hearing, we can't hear evidence, you can only do it on the allegations. And if Chutkan says otherwise, let's get this hearing going, Court of Appeals can reverse, they'll jump right up to the Court of Appeals and say, we have a right, because this is about immunity, for it not to be heard, and that'll go up, etc. And that's for the very first question. Mr. Pence, please come to the stand and state your name. That's for the very first question. And the Supreme Court, in essence, has given, there are obviously big chunks of this indictment that are not official and that will be tried at the end of the day if Trump doesn't become president. But it's the end of a long day after a laborious, like tear your hair out laborious process of separating fish from fowl, immune from non-immune. And I think it will be really not very hard for Trump and his lawyers to keep anything like that happening, real evidence, before the election. Okay, so that's the basic dynamic. We'll see. You have some very respected people. I won't name them because I don't want this to be a pageant of, who's right and who's wrong, but who are saying, no, we can now have a mini evidentiary hearing and let's have at it. But that's the issue to know about. One more quick thing. She also, during this time, it's been many months, Chutkan has had 5 big issues pending, and she decided one that she issued Saturday night, and that was Trump's claim that he is the subject of selective and vindictive prosecution, which basically requires him to show that they went after him on purpose because of the exercise of his constitutional rights. Not a general political thing, but for the exercise of constitutional rights. Chutkan made quick work of it and even sort of tartly dismissed Trump. She wrote, defendant is not being prosecuted for publicly contesting the results of the election, which would arguably be First Amendment activity, and that's why they're going after him, and that is vindictive prosecution. He is being prosecuted for knowingly making false statements in furtherance of a criminal conspiracy and for obstruction of election certification proceedings. And indeed he is. But whether that prosecution will get off the ground in any meaningful way before the election is, to my mind, really, really debatable. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.